Okay, this is, as you can see, this is a continuation of the presentation they gave about a month ago. And I'm not going to go over anything that I did in that presentation. I'm going to assume that you all remember everything that I said then, and we'll go on from there. Actually, that's not true. If you have questions, I don't know how you want to handle this, but if you have questions anytime through it that something's not clear or you don't remember something that I had said before, I don't know how you're going to ask them, but we can have them. But
we have a chat window. If people open the chat window, type questions, you can pass them along that way. And if Dick doesn't see them, that's correct, Bob. Chat works for questions. If Dick doesn't see them, I will say them at an appropriate time.
Okay. Yeah. What I had intended to do is this presentation is going to be broken down into 3 sections, and at the end of each one of the sections, I'm going to stop and ask for questions. So if that works for all of you, that's great. Okay, so the first section is a continuation going on from what I left off a month ago, where we were looking at the actual patents themselves, and I'm going to discuss how you read a patent so you get some sense of when you see a patent and all the gibberish that's in it and all the terse information that's there, that you have some sense of how to look at it and how to interpret it. So the slide that I showed last time was the one that's up there right now. It's difficult to read, so I'm going to skip past that. This is the first, the top of the front page. The front page of a patent is put up or put together by the patent office once the patent has been allowed and is issued. So this is all done by the patent office, the front page. Last time I went through what's on the front page, a lot of information here. I went through this, but there's a couple things that I forgot to mention last time that I'm going to mention right now. Can you see my cursor? Steve, can you see my cursor?
Oh, where is it? I don't see it.
It's in the slide. It's not there. You can't see it?
That's right.
Okay. All right. If you go to the upper right-hand of this slide, you see the date of patent, February 17, 2015. If you go down in the left column, almost to the bottom where it says filed, March 22nd, 2012. So it's been about 3 years from the date that the patent was filed before it was issued. That's not uncommon. A lot of examinations take much more than that. In biotech, they take a lot more than that. 3 years is what the patent office tries to do. They try to have it issue within 3 years, allowed and issued within 3 years of the time of filing, but it doesn't happen all the time. If you look above that filed up to the asterisk where it says notice, it says subject to any disclaimer, the term of the patent is extended or adjusted under 35 U.S.C. by 219 days. That means that the patent, which I mentioned last time, is enforceable for 20 years from the date of filing. In other words, it would be enforceable until March 22nd, 2032. This patent will have that extended by 219 days. The reason for the extension are various. One of them is that something happened during the prosecution of the patent application so that it got slowed down. And it could have been something that happened in the patent office. It could have been some other situation that arose so that the patent didn't go through in a normal channel or the normal way. So it can be extended. And this is something that the patent office will do if something untoward had happened during the patent prosecution. Okay, so if you take the filing date was March 22nd, 2012. Now, if you look at the top left of this slide, which is the bottom half of the front page, you see it says related U.S. application data, provisional application, filed March 25th, 2011. The reason that this is in place is because this is when the patent was filed, and or the provisional application was filed on a particular date, and the law states that you must file your actual application to be examined within 1 year of that date, or else you lose the provisional date as far as priority is concerned. So this was filed, if you remember the previous slide, this was actually filed almost a year from the provisional application. That's very common. Most people who file applications will put in a provisional application to begin with, and then wait almost almost a year. I've done it where I've filed exactly 1 year. If I go over that, then I've lost. But it's typical that you go 1 year. The reason people do this is so that they have time to work with the invention to see if it's going to be viable, to see if it might have commercial value or whatever. And so that just gives you some time. The provisional application is not published, so nobody knows about it, but the actual application itself is published. So inventors typically wait to see if it's going to work, or see if we should go ahead and actually do the application, go through the actual examination process to get it issued or not. They usually wait up to a year. You can always do it earlier than that. And you could always file the application to have it examined whenever you want, and just go ahead. So you got that 1 year time frame in which to play with. All right, now let's go into the actual patent itself. And I'm not going to go through everything here, but unfortunately, what I'm going to do is read certain sections to you, which you'll see on your screens, and try to discuss what is in here, why it's there, and so forth. All of the rest of the patent that you'll see from now on is something that the actual inventors, or the applicant as we call them, we call the inventors or whoever submits the application, the applicant. So I'm going to use those two terms interchangeably now. At the top left of this, you see related applications. And that's exactly the same information as I just talked about as far as what the provisional application was. The patent as it's published, as I just mentioned here, is almost entirely what was submitted to the patent office as the actual application. There are no changes that take place, with one exception, which we'll get to in a couple of minutes, well, maybe 5 minutes. There can be changes here if the examiner allows it. Now, the examiner actually has charge of what we call prosecution of the patent. And in my next section, I'll go through how one obtains the patent and the examiner's role in it in a lot more detail. But here, I just want to let you know that if you ever file for a patent, you must have all this information this way in the patent application. You can't change it once you file it. Okay, so like I said, the top paragraph was just restating the provisional application thing. So people, when they read this, they'll know that there was priority back to this point. And I'll talk about priority a little bit more later. The next field you see is called field of the invention. Now, what's in this application is typical, but it's not required to be quite in this format. Most of the time, the patent applications, the patents are in this format just because it's easy. It's something that everybody has been using for years and years. So that's how it's done, and it complies with the laws in terms of getting the actual patent prosecuted, allowed, and issued. Field of the invention, that just gives you a general sense of where this invention occurs. It says present invention relates to weighing devices and more particularly to weight monitoring systems. If you recall from the last presentation, this particular patent I put up here for two reasons. First of all, it came from the computer area of examination, believe it or not. Secondly, I put it up here because I thought that the subject matter was pretty simple and everybody would be able to understand it. A lot of the patents, as you well can imagine, are quite, what I want to say, they're quite difficult to understand. to a lay person, or even somebody that knows a lot about computers. They're in a particular area that if you haven't been working in that field or haven't come across it, you really have a difficult time reading them. So I didn't want to put one of those in, just, for purposes of making it simpler. The next area you see is the background of the invention. Now, this gives you kind of a summary of where the subject matter of this patent fits into the general technology. So it says here, it is often necessary or desirable to weigh athletes to track and assess their condition or status. For example, members of an athletic team may be weighed before, during, and or after each practice to monitor their hydration. So with that, for these two sentences, you now have some sense of what kind of technology, quote unquote, this patent fits into. The next section says summary of the invention. I'll just read the first paragraph here. The reason I'm reading it is so that you get some sense of how the structure of the layout of the patent is put forth, and the flow of it is very similar in all patents. According to some embodiments of the present invention, a weight monitoring system includes a biometric identification input device, a body weight scale, and a controller. The controller is operative to identify a subject using identification data acquired by the biometric identification input device, to store weight data for the subject acquired by the body weight scale, and to correlate the weight data with the subject. Now, you probably would know that from what I had just read about the background and what we had said before about this, what this patent was for. But what's happening here is this is an overview of what the invention is. And one term that I went over here says some embodiments. That's a very typical term in patents. Embodiments are what the inventors think of as a way for the invention to arise within the general, BU. So one goes out and actually practice what we call practicing the patent, making the patent work the way it's supposed to. That's an embodiment. And most inventions, as you probably can imagine, have a lot of embodiments. You could do it lots of different ways and still fall within what the patent is trying to cover. So what's been stated here is in some embodiments of the present invention. There could be others, obviously, beyond what's stated here, but the inventor is trying to tell you, at least in general, what these embodiments are or what the invention is. I won't talk about the other two paragraphs here. So I want to jump up to the top of this page, excuse me, into column 2. And it says brief description of the drawings. Most applications, particularly in the computer field, mechanical also, will have figures. And the figures are required if they make it easier to understand what the patent is directed to. Figures are not totally required if they are not needed. But in these areas, usually you'll find figures there. Sometimes the examiner will actually, during the examination process, will actually request that figures be submitted. That's not common. But sometimes, occasionally, that happens. In this instance, you see that there are 21 figures here. I didn't show any of the figures in here, but you could go to this patent and you look it up and see what all the figures are. They're pretty straightforward. They're flow charts and pictures of the invention. That's really what the figures are. When they say a brief description, it's usually one sentence that tells you what that figure is directed to, what it's supposed to identify. Hang on a second, something's come up. Okay, figure 1 is a flow chart representing methods for monitoring a subject's weight in accordance with methods of the present invention. Yes, it's a flow chart. Okay, you all know what that is. That's all that figure was directed to. The next section is called detailed description of embodiments of the invention. Here, the inventor is, or the inventors are going into much more detail about what the invention is, describing it in some detail. So let me read this paragraph here to give you some sense of how this feels as you read it, and particularly in comparison to what was in the summary of the invention. Typically, the detailed description goes through what was in the summary, but describes it in much more detail, much finer detail. So here it says, the present invention now will be described more fully hereinafter with reference to the accompanying drawings in which illustrative embodiments of the invention are shown. In the drawings, the relative sizes of regions or features may be exaggerated for clarity. This invention may, however, be embodied in many different forms and should not be construed as limited to the embodiments set forth herein. Rather, these embodiments are provided so that this disclosure will be thorough and complete and will fully convey the scope of the invention to those skilled in the art. I want to emphasize that last term, skilled in the art. I'm going to come back to that. Now, as you can see, what's going on is that the inventors, the applicant, will really go into detail to the point you say, well, that's obvious that that's what you mean. That's, yeah, we get that. But you want to, the inventors really want to put it in here as much detail as possible. The reason being, if you get into litigation, there's all kinds of ways that patents can be challenged or can be upheld. And you put as much in here as you can to help yourself in case you go into litigation, you have to defend the patent. So they'll go overboard, or, you know, we as applicants will go over, we inventors will go overboard and spend a lot of time on these detailed descriptions of what the patent is. Let me think a second. Yeah, there's nothing more that I want to state here. There is one other part of this particular patent that doesn't show up, and that is when they give examples. Many times patents will have, toward the end of this area here, they will end up this detailed description with giving examples where they go into great detail about particular, very specific ways in which the patent should be practiced, as we call it, or used, or you can conceive of what it really is. It's like when you write papers for journals and so forth, where they actually go in how they did those experiments. You're summarizing in some detail the experiments, how it was done, the results, and so forth, and what the results mean. That will be in what's called examples. In this particular patent, there were no examples, and that's okay. As I said before, the specification, which is what this is called, this area is called a specification. There's no strict requirement for what's there, except for what I'll go through in the next section of this presentation. Okay, with that, let's go down to the next, hopefully the next slide. There we go. All right, so now we're in columns 13, 14. We're getting toward the bottom. At the end of a patent, you have the section which is called the claims section, or the claims. This is the most important part of any patent, the claims. The claims are what the invention is, very specifically, or in general, as you'll see here, what the invention is. This is the invention for legal purposes. And so a lot of time is spent on these claims, both by the applicant and particularly by the examiners. All right, now you'll see in the left column there, you'll see that which is claimed is, and I want to read this. Number one, a weight monitoring system comprising, and comprising is a term of art in the patent field. You'll always see that in the claims. There are two other terms that might be there that other than comprising, but that's it. You'll always see one of those three terms at every claim, right at the beginning. comprising, which is what you can think of. This is what it is. I'm going to tell you what it is. A biometric identification input device, a body weight scale. Like the identification device would be something like a photograph or a fingerprint or something like that. A body weight scale, just a scale or some way of weighing someone. Then, and a controller. Okay, this is where the computer aspect came in. Operative to enroll a plurality of subjects, including acquiring and storing biometric and biographical identification data for each of the plurality of subjects. Thereafter, for each of the plurality of subjects, authenticate and identify the subject using identification data acquired by the biometric identification input device, store multiple weight values acquired by the body weight scale for the subject at different designated weigh-in time points, and correlate the weight data with the subject. Index each of the multiple weight values to its corresponding weigh-in time point. Now, programmatically analyze the weight data to determine and identify subjects who have lost more weight than a prescribed threshold weight loss between a first weigh-in time point of the subject and a subsequent weigh-in time point of the subject, and programmatically report the identification or identifications of the subject or subjects who have lost more weight than the prescribed threshold weight loss between a first weigh-in time point of the subject and a subsequent weigh-in time point of the subject, including issuing a visual and or audible alert. Now, at first blush, it looks like they've thrown, like there's a lot of fluff that's in here. But if you look at it, it's very, very specific. It's right to the point of what the invention is. Another feature is that if you look at it, every claim is one sentence only. Claims must be only one sentence. Okay, so that's why you see these breakdowns into subsections, you know, in English, how we have broken down, how we've, when you diagrammed your English back in the elementary school, you can see all these phrases and so forth and how it's put in. That's very, very important.
Well, number 9 is quite a sentence.
What's that?
Number 9 is quite a sentence.
Yeah, well, 9, I'll get to 9 in just a second. But this is number 1. And at the end of my presentation last time, I had a few people say to me, well, this is pretty simple. I don't see how you can get an invention to this. That's not uncommon. All inventions are not earth-shattering. In fact, most aren't. Most are just changes and are what we call inventive over what was done previously. No, I've had a lot of experience in patents. You know, the second half of my career was in patents. And I haven't looked at the how this patent was prosecuted. I can go into the files and look at how the patent was prosecuted. But let me give you an idea of why I think this patent was allowed as an invention. I think when the inventors submitted their patent application, they stopped right at the area above the first programmatically analyze. And they found that that wasn't patentable. So what you see is those two programmatically analyzing phrases add something very specific to weighing people, identifying the people, putting them into a computer system so you can make analysis of them across different athletes or individuals and so forth. I think it was because they added those last two phrases that made this patentable, as we call it. In other words, an invention that could be allowed. I don't know that for sure, but just the way that it looks to me and sounds, that's what I think has happened here. As an aside, when I was an examiner, there was only one application. I was an examiner for about 3 years, and I went through a lot of applications. There was only one that came in that I thought, boy, this is truly, really inventive. This is something that no one's ever seen, and I've never even thought about this before. Only one. The rest of them, I said, well, is there a patent here or not? And when I get into my next section, I'll go through a lot of the thinking that examiners go through in order to say whether an application should be patentable or should not be. Okay, that's number one. Now, somebody said that look at number 9. If you look at number 9, number 9 says a method for monitoring, that's on the right-hand column, column 14. It says a method for monitoring subjects' weights, the method comprising. Now, this is what's called a method claim, whereas claim 1 was to the system. It was a system. So it's an actual machine. Claim 1 is to a machine. Claim 9 is to a method. But if you read down into claim 9, it's almost the same identical language as claim 1, except now they've made it, they put in providing, using, enrolling, in other words, active words. That's why it's a method, but it's exactly the same language as in claim 1. It's just that now they've made it into a method claim. Each claim by itself is an invention. So when people in the patent field talk about invention, it's used lots of different ways. It has lots of different meanings depending on the context in which that term is used. The invention, yes, is to the overall patent. But within the patent, you have different claims, separate claims. Each one of those legally is an invention, separate invention. So if one gets into litigation, often what happens is that the particular claims are the ones that are being either attacked or are being used if there has been encroachment on your patent. Okay, so that's what's going on here. Now, let's go to the next slide. Now, what I've done here is looked at the bottom of those page of that page that I just showed you before. So the top of it is exactly what was in the previous slide. But toward the bottom here, you'll see on the left-hand side, you'll see 2, 3, 4, 5, and 6. And let me go to claim 2. Claim 2, which is halfway down on the left side, it says the weight monitoring system of claim 1. Okay, what's happening in claim 2 is this is a claim which is dependent upon claim 1. All the information that is in claim 1 is now being subsumed into claim 2, but now claim 2 goes on and says, wherein the controller is operative for each of the plurality of subjects to automatically, programmatically authenticate and identify the subject using identification data acquired by the biometric identification input device, store multiple weight values acquired by the body weight scale for the subject at different designated weigh-in time points, and correlate the weight data with the subject. Index each of the multiple weight values to its corresponding weigh-in time point. So what's happened here is that now we've gotten to more detail about how this invention is being used. It's more specific. And that's what happens with dependent claims. They become more detailed. They're what we call finer in scope. They're narrower in scope than the independent claim, which was claim 1. Yeah, that's one thing I did say. Claim 1 and claim 9 are called independent claims. And then claims 2 through 6, and on the right side, 10 through 13. Those are dependent claims. That's just the terms that are used. Each dependent claim can only depend upon a previous claim. So claim 3, for example, says it's a weight monitoring system of claim 1 and so forth. It does not include the information of claim 2. It only includes the information of claim 1. You can have dependent claims that depend upon dependent claims. So you can get finer and finer as you go through. So you can think of it in your head as sort of an algorithm where you have at the top the dependent claims, then you have the independent claim, and then you have dependent claims coming down from it. And so you can have several dependent claims coming off that independent claim, or you can have a line where you go down through dependent claims depending on previously dependent claims and so forth. On the right-hand side, you'll see Claim 10, which you obviously came after Claim 9. Now, Claim 9 was to a method. Claim 10 now is the weight monitoring system of Claim 1. So now Claim 10 is going to depend upon independent Claim 1. In other words, it's to the structure. Okay? Claim 11 is to Claim 1. Claim 12 is to Claim 1. But Claim 13 says the method of Claim 9, wherein the subjects are athletes, the first weigh-in time point of each subject is executed before an athletic practice session, and the subsequent weigh-in time point of the subject is executed following the athletic practice session. Okay. The format for the claims is not too important. It's nice to have all of your dependent claims following the first independent claim be in that order, and then you go to another independent claim from which you can have dependent claims. In this instance, that's not what happened, but that's okay. As I said, this is the most important part of the patent, and this is where changes can and do, and very often, if not always, occur during the examination process. The actual language of the claims changes, and it changes as a result of the examination process. The examiner might say, for example, well, you haven't really made an invention here. However, in your specification, which was the previous area, you said something so forth, and perhaps if you put that into the claim, now it would be allowable. That's an invention that I see. And so the claim gets changed. The claim always is changed when the inventor tries to change it. The examiner, I won't say never changes language in the patent application. They are not. They can't do that legally. What they can do is request the inventor to do so, or to agree to do it. Toward the end of an examination, just to quickly get this thing wrapped up and get it allowed and get it out, the examiner says, "Look, I'll make this change to the claim language here if you allow me to do it, and we'll just pass it on." And the inventor will say, "Okay." The examiner then will put in the language, and it goes on. However, the inventor must okay that, and it has to be done in writing, or here, it's done electronically, and this is allowed to be done. Other than that, every change that occurs by the inventor trying to have it happen. In other words, they've been asked to do it, or they wish to do it in order to get the application allowed and issued as a legal document, as a patent. The last thing about these, the patent itself, the preceding pages, other than page 1, page 2, or page 1, the one that the patent office puts together, is all, as I said before, is all submitted by the inventor or the applicant, and it doesn't change, with very rare exceptions, which I won't go into. They're minor things that could happen, but other than that, it's exactly what's in. So when an inventor submits a patent application, they have to know that this is it. This is what they're going to have to live with when they go through the examination process. The term specification is also another term in the patent field which is used in two different ways. The specification is really everything that I have talked about other than what was on the first page, or page 1 that I talked about. This whole thing is called the specification. However, when one is examining or anything like that within the patents themselves, Usually we think of the specification as everything up to the claims, and then the claims are what's left afterwards. So we usually talk about the specification, and then we talk about the claims. Now, in the next section that I'm going to, that'll become a little bit more apparent about what's happening and why we do it. So this is the end of the first section that I wanted to talk about. So I want to open up for questions now, if I could.
Okay, Dick, we do have one question. Jerry asks, if a person has an existing patent, I think that's what he meant, and later makes an improvement in the product, how do they protect the improved product? I think they have to refile a new patent. What is the deal here? Should they start again, or should they add an addendum? By the way, if you open up chat on the bottom of your screen, you'll see these communications.
Yeah, I thought I could too, but unfortunately on my screen, all I have is my presentation.
That's okay.
I blocked it. So reading it to me is, yeah, probably the best way, and then everybody knows what we're talking about too. Yeah, Jerry and Steve, you're both right. Typically what happens is if there's an improvement, and improvement itself is a term of art in the patent system. Improvement really means, of course, that you've done something better than what that patent, what that invention that was described in that particular patent was. You've made it better, you've done something unique, and it's patentable by itself. There are two ways that you can do that. Let's say it's the same inventor, or at least one of the inventors of a particular patent. It has gone on with either the same inventor that cooperated to begin with, or with other inventors, and made an improvement. They can file what's called a continuation in part, or a CIP, in which they claim priority to that information which is in the original patent. And now what they're doing is they're claiming that aspect, which is the improvement thereof.
Okay, let me ask you a direct example. For example, if you can give me an example, I'll give you an example.
Sure.
I invented a hand grenade, and then about 2 years, and I patented. And then about 2 years later, I invent the pin to keep it from exploding. So the pin itself would not be a patentable device.
Right.
But
along the same line,
it improves the functionality of the hand grenade immensely.
Yes.
So what would I do with that pin?
Well, as you said, the pin by itself is not patentable. The pin as part of the hand grenade probably would be patentable, because what you have is a machine which has the hand grenade plus the pin.
Is a new patent?
Okay, you can get it. Yeah, like I said, you can file what's called a continuation in part, a CIP. That's a new application for a new patent. Yes, you can file that. But here's the downside of that. You can only claim, you'll get 20 years from the date of filing that improvement or that CIP application. Okay. It's probably better. In fact, what will happen today, more likely than not, is you'd file a new application, a brand new application. You wouldn't depend on this one. You'd put it in, because in and of itself, it's an invention. So you're just cleaner. It's better. And in fact, that's the way it's done almost typically today.
And would the old patent carry weight with the?
No.
They're saying you've already got the patent, and it improves the functionality.
Here's the downside, though. That previous patent is now prior art to your new patent.
But you own it.
So the hand grenade itself is now prior art against you.
But it's your prior art.
It doesn't matter.
So if there's prior art, you may not be able to patent the second part.
It's possible. I mean, in the instance that you've given me, the actual example you've given me, your new invention, I'm pretty sure it would be patentable over your own prior art. That's not uncommon, where inventors keep filing patent application after patent application, building on what they did before.
Because in the medical business, in the medical equipment business,
yeah,
you have your first generation equipment,
right,
which often, frankly, they rush to market for good reason.
Sure.
Then everybody sees it, including the original inventors. And so the second generation device is usually far superior.
Yes.
To the first one.
Yes.
How they handle those patents, because they obviously want to control their device.
Right.
to those.
Okay, what will happen in instances like that is you have to assess whether that improvement is in of itself patentable by itself. If it's not, then you'll claim priority, what's called priority, as to the original patent application, and the original application now is not prior art because it's part of this lineage of patent applications that you've made. And it's just that improvement, if it is patentable, then a patent would issue on it using all the information that was in the original application itself. So then it doesn't become prior art. But it's only if that improvement is of itself not patentable, but only because it relies on the information in the original application. That's a decision that has to be made by the inventor or people like myself who are attorneys that work in this field that prosecute the patents. And so we go back and forth with inventors all the time to try to figure this out. What's the best way to do it?
Okay,
Is
Dick?
it very dangerous for something to become prior art? Because if it's prior art, then other people could use it for their own purposes.
Well, no, they couldn't do it as long as that patent is enforceable. Right?
It doesn't take away the patent.
No. The original patent is there for 20 years sometime.
I see.
Yeah. You don't lose it just because you add to it.
Okay.
Let me give you an example.
Or they say it's prior art.
Yeah. It's only what you have to think of, what one is concerned about is your own prior art. That's very common in all areas of technology where the inventor keep inventing and the worst prior art against them of them not getting the invention is their own publications, their own patents. That's very common. It used to be, see, when I first started, and I think probably all of you who have had patents, it was the old system of where first to invent was the one that got the patent. And you saw this, you saw these continuation in parts kinds of applications a lot more readily then. Today, we're in a first to file system. So it's the filing date that matters in terms of the exclusivity. Back in the days when it was first to invent, the exclusivity was 17 years from the date of the patent issuance. It had nothing to do with when the patent was filed. It had to do with the issuance of the patent. 17 years. Today is 20 years from when the patent application was filed. So it's first to file system. So you don't see it very often because if you want to have
people.
Pardon?
Terry, can we give somebody else a chance to ask a question?
Go ahead.
Okay, Dan, you had a question. Could you go next, please?
Okay, yes. My understanding is that for
Turn off the speaker.
everyone's in the same room.
Dan, have Evelyn just mute her microphone.
Mute your speaker.
I'm sorry, speaker.
Yes.
Still echoing.
Let me another way.
Harry, did I answer your question?
Yeah, well, I can see how people could fool around. If I had a 10-year-old patent, if I make some minor adjustment, I could get a new patent.
Yes.
My original patent with a little bit of fooling around, which might or might not be meaningful.
Yeah, you can get a new patent, and now it's 20 years from when that application was filed.
Right. So I could extend my patent
Yep.
by making a very minor modification if I could make a decent claim on it.
That's right. And as you all know, particularly those of us or those of you in the medical field or in the pharmaceutical field, that's how patents are extended. So the patent protection goes on and on and on for years and years. By these
You'll notice while we're waiting, you'll notice that there are many drugs that just as they come to the end of their patent life, a time release formulation comes out from the same company.
You got it.
Gary,
You got
Dan,
it.
let's give Dan a chance, please.
Yeah, go ahead, Dan.
You gonna get in now?
Can everyone hear me okay now?
Go ahead.
Okay, my understanding of a prerequisite for a patent is that it must be novel, useful, not obvious to someone skilled in the art.
Correct.
Is that correct?
Yes.
Now, in this particular example, it illustrates something that seems awfully obvious to me. If you want to know if a team member is losing too much weight during a workout, well, measure everybody before, measure them everybody after, have a computer process the data and give you a warning. So how does the examiner decide whether something is obvious or not?
There we go. Good question.
I can talk about something from my own experience, but I think this is a sufficient illustration.
Yeah, let me, what you've done beautifully, Dan, is led me into the next section that I'm going to talk about here, about how the examination process occurs. Because that's a big issue. It's a major issue in the examining process in terms of how you actually get a patent. It's a big, big, big thing. And that's the big thing that happens all the time in examination. This
Dick,
one is a very good example of that.
Just before you get into that.
Oh, go ahead, Steve.
Okay, Charlie Halborough had a question. Go ahead,
Yeah,
Charlie.
it's kind of a minor question. I was wondering what happens when there's a typo that changes the meaning of the patent. Earlier in this patent, they were talking about weight athletes, which means to me guys who lift weights. But actually what the context shows is that they probably meant weigh athletes. They were talking about finding what the weight of the athlete was. But there it was in print, weight athletes. Who decides to correct things like that?
Okay, something like this, the examiner might say, or might request the applicant to change that. So change weight to weigh. That can happen. That's a minor thing because from the context, it's evident to everybody what's intended here. It's just that the language itself, the English language itself, is not properly used. And as you said, it's probably a typo. Things that are real typos, yes. The examiner will allow the applicant to make those changes within the application. But it's only for minor things. If there's anything that just looks like it might be adding something which we call patentable or inventive to the application, they will not allow that to occur at this point. So yeah, that's a good question. That's a good point. It happens all the time. Anything else before I get to Dan's question? Okay. Okay, Steve, I'm going to go on. Is that okay?
Sounds like a plan for me. Go ahead.
Okay. All right. How does one obtain a patent? What I'm going to do here is give you a synopsis of what the Patent Office does and look at patent applications from the standpoint of the examiner. As I said in my last presentation, I spent the first part of my career in the patent field as an examiner. And I'm going to go into some, I'll give you some stories about what was happening there. I'm going to look at the patent application from the examiner's perspective rather than from the inventor's perspective. Now, when I asked in my last presentation how many of the audience had actually had patents issued in their name as inventors, I was pleasantly surprised at the number that raised their hands. It was like 30 or 40% of the people who were watching today or were there last time actually were inventors. I didn't expect that many. When I asked the question how many people had applied for a patent as an inventor, but the patent hadn't been issued, I didn't get any hands raised that I could see. That to me was most surprising because most patent applications that are submitted to the Patent Office do not ripen into a patent. They are not allowed as patents because during the examination process or for whatever reason, they aren't allowed. Now, the applicant could withdraw it, but let's say that they go through the examination process with the examiner. The examiner says, no, a patent is not allowable. I can't give you a patent for this. It's not inventive. That's most typical. In certain fields, the patentability is maybe at best 10%. Now, in the field of most of you in the computer fields, that particular technology has been around for some time, and a lot of what goes on is patentable. And so you do things that are patentable. It's just the way that the culture is in your field. So many of the applications are set, they will be allowed, they'll be patentable. So in the computer area, it's probably more than 10%, but it definitely is not 100%. If it's 50%, I'd be surprised, but it could be, okay? Just to let you know that that most applications do not come out as patents. And why it is because of the examination process. Something happened, and what was submitted is not patentable from the examiner's point of view. As you can well imagine, it is fairly subjective. However, it is based on objective criteria to the extent that we can do it, but that changes all the time. There's lots of what's called case law. Let me go back to the law a little bit. We have to have laws that are put forth, and as I point out here, all of the patenting that happens and all laws that govern patents are given by the 35 U.S.C. 35 United States Code. That's the law that Congress wrote. Okay, it's Title 35 U.S.C. That's the code itself. That gets amended or every so many years. Typically, it's been maybe between 10 and 15 years, that code is rewritten. So the most recent code for patents came into effect in 2013. The law was passed in 2011, came into effect in 2013. So now we're working under the 2013 code. In that code, one of the biggest changes that took place from the previous law was the first to file system. That's the first time first to file became the law as far as the enforceability or exclusivity of the patent. Now, under the code, we have the regulations, Code of Federal Regulations. This is what the agency writes up, sets forth, and this is what is followed. That's done by the Patent Office itself, usually writes up the regulations. That goes through a review process and so forth. And that's amended much more often than the code is. But these regulations go through in more detail how examining is to occur, lots of the legal procedures, lots of the legal things that happen in the patent field are handled, how the courts handle it, how the people in the patent office handle it, and so forth. Let's see. Yeah.
Hey, Dick,
Yes.
just an administrative issue here. It's a little after 11.
Yep.
Have about 20, 25 minutes to go on this session. And we had a couple of things that we were going to use for a filler based on your original estimate. I think we're not going to be able to do the filler. And just a heads up for you, if you want to figure out where's a good stopping point in about 20 minutes or so, we'll leave room for a little discussion before you quit. And if necessary, we can do part 3.
Okay. Yeah, I didn't realize that
One-
first part was
one
going to go
more-
that long.
One more item, if I may.
Yes, go
We
ahead.
have an opening in April because the gentleman that Bill Sharetta was bringing to talk about some automated cars is not going to be coming then. That gives us an open session. So my thinking was that maybe we'd take the stuff that Gary Patrick was going to use as filler for today, move that into April, and then you can finish up today with the exception of a 5-minute video that Steve was going to show, and then we'll just push the rest of the stuff out. Because there seem to be a lot of questions about your material, so we might as well do it. Unless somebody has an objection to that.
That's okay with me. Fortunately, I don't have to file my taxes by April 15th now. I can put that off till July 15th. So
Actually, you might, because Massachusetts has not deferred its taxes, and I don't
Yeah.
know if you can do Massachusetts without doing your federal.
yeah, I know. I've thought about that too. I'm assuming Massachusetts will. I haven't, But I'm aware that they might not, so I have to do something at least to
They
put
need
that
the
in.
money. Unlike the federal government, they just can't go print it.
Yeah.
Meanwhile, back in the patent office.
Yeah. Okay. This section I'm going into now is probably going to take a little bit more time because we're going to have more questions and it's a much more nebulous area. Okay. Let me go to the next.
Well,
slide.
Dick, why don't you just logically find a spot,
Yeah.
in about 20 minutes, when, just sort of keep half an eye on the time, or maybe I'll give you a couple of minute warning if you like, and then
Sure.
we can get to a place where we can stop, have a little discussion or whatever,
Yeah.
but, and go from there. Steve,
Yeah.
you get about 5 minutes for yours? You can nod.
Yes, 5 minutes.
All right, so let's tentatively look at 11:25 as the witching hour, and we'll see how close we get, Dick. Fair enough?
Yeah. Very good. Thanks. I'm sorry this is taking a lot longer than I thought it would. That's my
No,
fault.
it's a good discussion. No, it's nobody's fault. It's a good discussion, and people are hanging out, so they're apparently interested.
Yeah, as
So,
long as people are interested, I'm willing to go on with this. Okay. Now this is what the examiners will look at as an application comes in. When the application is filed, hang on a second. Let me go back a second here. Yeah. When the patent application is filed, there are certain formalities that happens. In other words, the application comes to the patent office and it's gone to what is called an application branch. And that particular group of people looks at the application to make sure that it complies with all kinds of legal formalities. So for example, it has to be in the proper form that patents have to be in, which I just showed you what the patent looks like. If there are drawings, make sure the drawings are in the correct form, and that's spelled out in those regulations. In addition, there are fees that have to be paid. The patent office subsists on the fees that are paid. It's one of the few agencies of the federal government that is self-sufficient. It is the fees pay for everything that the patent office does. Okay. Congress does not appropriate money to the patent office for carrying out its operations. In fact, many times more fees come into the patent office than are used to carry out its functions. That money is turned back over to the federal government for whatever purpose it wants to use them for. Occasionally it changes, but if you see, those of you who have been in this field for a while, the fees change all the time. So every year, they have to make an assessment of whether the fees are going to cover everything. And that's why the fees change. Let's see. Then what happens once that's done, let me answer a question that came up long ago about whether you can get a patent on something that might have national significance, that could be something defense related or something that perhaps should be kept secret. Yes, you can. I think it was Steve that had this question 2 or 3 months ago. Yes, you can get a patent on something that is secret. What happens is that when the application comes in, one of the things that the application branch does is they look at it. And is this something that might be of significance to the nation? They then send it either to the Defense Department or to NSC or other agencies for their assessment. Is this something that we should keep secret? Is this something that you could use, and so forth? That those people have a turnaround time that's usually pretty short to say yes or no. If they say yes, then patenting goes on, but within that agency and everything is secret. Okay? Typically not, and it comes back to the patent office and goes through the regular application process. Sometimes, I think as Lita mentioned when she gave her presentation, sometimes the agency will free it up for patenting to come out in the general public sometime later. And so the patent could have been issued, and now it comes back into the general population. And when that happens, they'll often, they'll often add on more time for enforceability for that patent. In that area that I showed you on page 1, where days were added, often that's what will happen, that the patent office will add those days. So now it's free to be marketed in the free market. So yes, you can patent secret things. That's not, it's something that can be done all the time, or it can be done. Now, When the patent applications come in, they're okay and everything. They go down to what's called the groups. The groups then give them to the art units. The art units then give them to the examiners. That's the flow. The examiners have their own area of expertise that they have built up over years of examining, and they go on and examine it just in those areas. When they do examine, there are two things really that go on in the examination process. What I've laid out here is the verbiage that are in the actual U.S. Code sections. Now, this is section 112, which deals with the specification. And as you notice, I've got paragraph B before paragraph A. That's not the way that it's laid out in the code, but I'm doing it this way because that's an easier way to describe what's happening. One of the first things the examiner does is it looks at the claims to see if they particularly point out and distinctly claim the subject matter which the inventor or joint inventor regards as the invention. You want clarity, the examiners want clarity of those claims. This is done for a lot of reasons. One is when the examiners examine, they want to know exactly what they're examining. What is the invention? What do you think in as clear terms as possible is the invention? So they do that for clarity there. Often the claims come in and there's ambiguities that the people who wrote the claims didn't realize. And so it allows the applicant to make changes to make it just much more clear of what the claims are and what you're trying to state as your invention. So the applicant will amend the claims. That's the term that's used in the patent field. You amend the claims, you change the claims. You can either withdraw the claim, or you cancel the claim and write a new claim, or you change the claim itself. Either of those is perfectly acceptable. So this happens often in the patent examining process. One of the features of a patent application that I didn't mention a couple of minutes ago is that every patent application must have a claim, or it will not be accepted. There must be at least one claim. That's not true for provisional applications. Remember, provisional applications are never published. And often what happens is that people, particularly in academia, are rushing to publish their paper. And so they get the paper out, and they've got a time deadline to get that paper out. It's going to be published and so forth. Oh, we got to file a patent application on this. So what happens is the paper itself is put in, and hopefully that paper is enough that claims could be written on it when the actual application is done a year later. Okay? So, but when the actual application that's going to be used to be enforced, yes, there must be at least one claim. You can always add claims, you can take claims out, you can, all this goes on during the examination process. But again, they have to be clear. And the clarity also depends on what the specification says, what's being described. Okay? Now, the next thing that the examiners do is they look at part A of this feature. It says, and this is the specification, it says the specification shall contain a written description of the invention. Very important, as the examiner is reading the specification, does it describe adequately what the invention is? Just in reading it, does it really tell what the invention is? In biotech, I found that was not followed to some extent. It's because just the language in patents is different than language in the publications to some extent. So it wasn't there. It wasn't common, but sometimes it happened. In computers and stuff now, hardly ever is this feature of the law a problem. So going on, and of the manner and process of making and using it in such fully clear, concise, and exact terms as to enable any person skilled in the art to which it pertains to make and use it. And I'm going to go to the next thing later. Okay, this is very important. This is called the enablement portion of the specification. The examiner wants to know, does this really tell the person that reads this patent once it's issued how to make and use this patent, this machine, the method, or whatever it is? It has to be there in clear, concise, and exact terms. Can somebody who has skill in the art. Now, a person skilled in the art is somebody who works in that field, who has experience in that field. That's what a person of skill in the art is, legally. Okay? It's not anybody off the street. It's not people from other technologies. It's somebody in that technology. That's what that term refers to. And it must be such that that person can make and use it just for what's being disclosed in the patent. Now, and shall set forth the best mode contemplated by the inventor of carrying out the invention. When the patent application is filed, the best way to practice the invention must be disclosed. Now, the examiner doesn't know that, but they're going to make the assumption that that's the case. Where this section comes up is in litigation, if it ever occurs. Patents are won and lost many times because the best mode wasn't presented. Now, what's meant here is the best mode at the time of the application. Subsequent to the application, people are working on this field all the time, working, you know, the inventors are changing things and so forth, and they come out with what would be called a better mode. That's okay, you can do that. So the best mode may not be the best mode when the patent is issued, but it has to be the best mode at the time that the patent application was filed. Okay, that's in the specification. Now, let's go down to 2 sections here. Novelty. I hope we can cover this in the next 5 minutes or so. Maybe not, we'll see. This really gets to what inventions are. Are they novel? I mean, most of you know what inventions are, but this is really the key. This is where the time is spent the most on. What novelty, what's novel? Now, this particular code section says a person shall be entitled to a patent unless, so this is like a negative that's put out here. Unless, number 1, the claimed invention was patented, described in a printed publication or in public use, on sale, or otherwise available to the public before the effective filing date of the claimed invention. Okay? Patented, that's in the patent, described in a printed publication or in public use on sale. If this particular invention is being what we call disclosed is anywhere out in the world before the filing of that application, then novelty has been defeated and a patent will not be issued. Okay? It's patented, described in a publication, public use, otherwise available before the effective filing date. That's a key word, effective filing date. What's an effective filing date? The effective filing date for a U.S. application would be either the date of the application itself or the date of the provisional application that preceded it. So you got like 1 year, okay? You can go back 1 year. Anything, any patent or anything that's going on, let's say more than a year before you file this application, and because you filed the provisional application, that does not destroy the novelty of your invention. Okay, is that clear?
Hey, Dick, I think this is a good place to maybe pause unless you think there's a good reason to go on.
Let me do part 2 of this. Yeah, let me do part 2 and then we can pause, okay?
All right, because I want to leave a little bit of time in case there's any questions.
Yeah.
Give Steve some time to do his video, please.
Okay. The claimed invention was described in a or an issued patent or in a public. The brackets I'm putting in here is because I'm changing the language just a little bit. Or in a published application for patent in which the patent or application, as the case may be, names another inventor was effectively filed before the effective filing date of the claimed invention. This has to do mainly with people having filed applications. In other words, you've got some other inventor, inventive entity is called, who have filed applications during the time that you filed your provisional, but before you filed your actual application. This part 2 here gives you priority. Okay, that's the reason for part 2. That's to get through this priority stuff. Priority again is for your provisional from a foreign person. It's when they file their application in their country. That's the date that's used. Those are the 2 main priority dates that are important. So it could be somebody in Great Britain filed an application in Great Britain during the time between when you filed your provisional and you filed your actual application. Your provisional will take priority because it was before they filed their application in that country, because they have a year from filing in that country to file an application in the US. And we'll go through that in my next presentation. But let me stop here because I didn't get to Dan's question about what goes on that looks like it's obvious. That's the next thing. And I know I would spend a lot more time because I'm going to go into what's obvious, the obviousness aspect. So let me stop here.
I've unmuted everybody so that, go ahead and ask your question.
Yeah, this business of first to file, replacing first to invent, doesn't that give a big advantage to large corporations with teams of lawyers?
Yes. It
So
gives a tremendous advantage to people who really understand the system. That is correct. You remember when I gave my first presentation that I didn't like it when the legal system went to the first to file rather than the first to invent. But as was pointed out, as we discussed during that presentation, one of the big reasons why we went to first to file is because the rest of the world went there. And patenting is going much more worldwide now. We're getting there. And that's something that I was going to end my presentation as to tell you where we are in the world as far as the patent system is, patenting it goes on. But that's one of the big reasons we went to first to file. The rest of the world had pretty much gone to first to file. But yeah, you're absolutely right. You got to have, you got to be aware of stuff that's out there in order to do this. But it's just the way it is.
So because the rest of the world wants to screw the small inventor, we will do it too.
Boy, you are stating exactly the way we were talking about, A, within the patent office, and B, as applicants ourselves. Yeah, you're absolutely 100% right.
Okay.
Dick, last question we can handle quickly before we go on. Laura asked, how does one become a patent examiner?
Good question. I did cover that. Good question.
If you can do it quickly, please.
Yes, if you become a patent examiner, A, you have to have a accreditation like a bachelor's degree, at least in a technical field, physics, chemistry, engineering, so people who have a math degree cannot become examiners. B, you have to pass a test that's given by the patent office in order to practice before the patent office. You do not have to be an attorney, okay? That is not required to practice before the patent office. It's only when you do legal things in courts and so forth, you have to be an attorney. But otherwise, you can practice before the patent office. And those are the only two requirements. That examination is not easy. It's based on that exam is not easy. It's based on lots of things that we have talked about here, great detail. Those are the two requirements.
Thank you.